and forfeiture instead of just that.
I think it's a classic case where they didn't take it to affirm, although of course sometimes they change their mind.
That's right. Sophisticated 30-second one. Okay, I think we'll get started. I want to thank you for joining us, those of you who braved the weather today to come out, and those of you who are local that did the very understandable thing and stayed home and or in your office to watch, and everybody else who's joined us, thank you for being with us. I'm Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 42nd year of free enterprise, public interest advocacy, education, and communications on a wide range of issues that affect the free enterprise system and separation of powers. In addition to putting on programs such as this, we do 3 times a year on the court. We do other issue programs, both briefings and webinars, as well as publish on a wide range of issues through our Legal Studies Division. We started 42 years ago as a litigating group, and that is what I think our backbone continues to be. We're very active this term in the Supreme Court, as we always try to be. We've gotten a positive result so far in the Weyerhaeuser case. There's 6 cases that we filed in as amicus that have been argued: the Apple versus Pepper, Nick versus Scott, Home Depot versus Jackson, Fourth Estate versus WallStreet.com, Merck versus Albrecht, and Nielsen versus Preapp. We have 4 arguments that are coming up in the second half of the term, 2 of which we have filed briefs in already: Hunt versus Cochise and Kaiser versus Wilkie, and we'll also be filing briefs in the partner drilling case, but we also filed at the cert stage in Emulex, and we're still waiting on 2 cert petition amicus briefs: the In-N-Out Burger case and the Atlantic Richfield versus Christian case, where there was a request for the views of the Solicitor General on that. I'm going to announce our speakers in the order in which they're going to speak, and then I will step aside and let them get started. Leading off today is Elizabeth Papez, who's a partner of Winston and Strawn, where she co-chairs the financial services litigation practice. She previously served as a law clerk to Associate Justice Clarence Thomas in the U.S. Supreme Court and U.S. Court of Appeals for the Sixth Circuit Judge Danny Boggs. Following Elizabeth will be John Elwood, who's a partner in the appellate practice group at Vinson and Elkins. Prior to joining the firm, Mr. Elwood was an assistant to the Solicitor General of the United States and the senior deputy in the Justice Department's Office of Legal Counsel. He writes the Relist Watch column for SCOTUS blog, which I know everybody reads religiously. Finishing up today, we'll have Kimberly, who is a partner with Mayor Brown, where he briefs and argues complex appeals and trial court motions with a primary focus on the antitrust laws, environmental law, and constitutional law. He co-directs the Yale Law School Supreme Court Clinic and served as a law clerk for U.S. Court of Appeals for the Ninth Circuit Judge Michael Daly Elkins. Elizabeth, you could get us started?
Sure. Thanks so much to Glenn and the team here at WLF. It's always fun to be part of such a great panel. John, Michael, and I hope Glenn will help us have some interesting conversations today. I'm going to talk about principally 2 cases. The first is the Emulex Grant that Glenn mentioned in the security space, and the second is the False Claims Act case in Cochise. The Emulex Grant, I'll start. I think it's a fantastic grant, very exciting case for a number of reasons, not least for capital markets. This is a huge case. And also for, a separation of powers nerd, some really interesting legal issues, some of which the court may reach, some not. The upshot in the case, this arose out of, this kind of, trench of merger objection litigation. The stats in the briefs are pretty staggering, right? We're talking about a lot of M&A activity. This one was a tech M&A case, deal that involved a tender offer for what are now some Broadcom subs in California, but the briefs talk about how we're talking about north of 85% of mergers in this country are the subject of litigation in the weeks following announcement of the deal. So very significant financially, very significant in terms of the impact on access to capital and cost of these transactions to our economy. So from an enterprise perspective, and then the rule of law and what we see as litigators, really important. This particular one was a tender offer context, so it was a situation in which, the acquiring entity approached the shareholders of the target directly and offered to buy their shares at a premium to market, which is normal course. What happens in these cases, obviously, is the person who's subject to the offer has to say, do I want to sell at that premium? Case arose under the securities laws, which say, obviously, when you do this kind of thing, there should be some disclosures around it, and you can't have anything fraudulent or misleading or the like in the process of saying, I want to buy your shares, and why is this a fair price? And what happened here, as usual, is they had a financial advisor. In this case, it was Goldman Sachs. They did a fairness opinion. They took a look at the price and the deal, and they had a board book, and in the board book was a slide that said, hey, the premium for these shares that's being offered is maybe on the low side of what we see in the relevant space, but it's fair. The lawsuit arose because there was an issue around whether that should have been disclosed. There was a claim that this was not just fraudulent, but negligent in not allowing this. The district court threw the case out in line with 5 other circuits. It said, look, we don't know that there is a private right of action for this sort of case. This is a tender offer case, so it's 14E of the 34 Act, a lot like 10B, but not the same, and said even if there is a private right of action, you're talking about a negligent failure to disclose this one statistic, and we don't see that that's a cause of action. So the district court threw it out, went up to the Ninth Circuit. The Ninth Circuit reversed. It said there is a private right of action to file this lawsuit, which was significant insofar as the jurisprudence and where I think the Supreme Court is now, but was in line with the 5 other circuits, where the Ninth Circuit parted company was saying, we think it's fine to sue for negligence as opposed to fraud and have to plead scienter. That was obviously tremendously significant. We've seen this movie before. We saw it in Stone Ridge with the 10B cases, and the whole issue of secondary liability. If it's not fraud, then you can go after people like the banks who do the, fairness opinions and act as financial advisors on these transactions. The litigation costs soar. It's a staggering impact on, transactions and capital. So obviously, the petition comes along and says, look, there's a clean circuit split, which is absolutely the case. It's 5-1. Ninth Circuit admits this. And then there are kind of 2 issues, I think, doctrinally that are interesting. The first issue, which is kind of the separation of powers issue that kind of lurks, is should there be an implied private right of action for this case at all? That's a threshold issue. In the securities laws, there are 8 express rights of action. The implied private right of action jurisprudence, I think, as everybody knows is listening in the court, sort of went along happily till about the mid-20th century. Then the court stopped and said, wait a second, we're reading in here something that Congress didn't write. Should we be a little bit more circumspect about this? From Sandoval forward, the court has said we've sort of sworn off the habit of reflexively reading in remedies that Congress didn't put, particularly in an area like securities where you have a regulator. The SEC has the power, for example, to regulate negligent omissions and seek injunctive relief for that sort of problem in a merger context. We've also got 10B as a robust framework. The chamber brief, the Wachtell chamber brief on this is actually very good in saying, look, you could get at this through 10B if you needed to. So it's sort of redundant to, extend the jurisprudence on implied private rights to 14E. And, really, this is an extension because everyone was doing this until 2016 under Delaware law. They were doing this, merger opposition litigation. They were getting these so-called disclosure settlements, where they'd file quickly and say we have a problem, and then because people wanted to get the deal done, they'd do a disclosure settlement where there was really no value to the shareholders. Plaintiffs' lawyers would get a lot of money. They do just a couple of usually immaterial, if you look at the statistics, I think, disclosures, and then you'd have a really broad release that would sometimes permit legitimate causes of action that may arise later. So I think from the standpoint of regulators and people who want to keep fraud out of the capital markets process, this is just as important as it is for the defense bar. So the threshold issue in the case is this issue of should we have a private right of action at all, an implied private right here? I think it's an important question. The petition says the court need not reach it. I think that's likely true, but nonetheless it's there. And then the secondary question is obviously tremendously consequential. If the court's going to say that there is an implied private right, can it be for negligence as opposed to scienter and fraud? And, you know, there, I think if you look at the text and the history of the statute and you look at the analogs and just, you know, the PSLRA, how the 10B jurisprudence has evolved, Stone Ridge cases like this, we really do want to cabin any implied private right of action here to something that gets at fraud. Otherwise, we're going to blow this open again to secondary liability. A lot of costs and consequences that frankly belong across the street in Congress or in the legislature rather than in the court. So I think it's a fascinating case. Great issues, great briefs, certainly one to watch. I think both if you're doing front-end work for the many, many clients and also, you know, regulators who play in this space and also litigating some of these issues in your cases going forward. The second case is another interesting one. This is the Cochise case. It's the False Claims Act case. It's the, you know, I feel like that statute's the gift that just keeps on giving insofar as, you know, experimenting with this idea of deputizing private attorneys general and then figuring out what exactly does that mean in the context of this statute with some really tremendous practical consequences, as Glenn and his team have pointed out in their brief and the Chamber has amplified. This case is one, the headline for stakeholders, again, both on the regulatory side for the government and for relators, and for anyone who does business with the federal government, which is pretty much everybody, is when are these False Claims Act cases timely, or I should say time barred, right? That's the headline. So everybody should be watching the bottom line in this case to know when they need to bring their case if they want to bring one, and when you have a clean shot at dismissing one if it's time barred. So that's the headline. When you unpack it, it's actually quite an interesting case. I won't have time to go into it in detail other than to say it's around the limitations period. The original limitations period said you have to bring one of these suits within 6 years of the time the fraud occurred. It ended up in the 1980s, I think it was in 86, in the amendments they added, you know, what's sort of commonly referred to as a tolling provision, obviously in fraud cases sometimes. And I think this was the whole, it's interesting, the whole historical impetus behind these cases. I think it was the cannons in the Civil War, right? The government decided our eyes and ears can't be everywhere. They were getting defrauded by paying for cannon that were supposedly delivered to a certain field when in fact they were not. And they said, okay, well, we're going to let these relators, right, these private attorneys general be our eyes and ears. The whole issue in fraud cases is there may have been a fraud. If it was, you know, maybe remotely successful, people wouldn't know about it immediately, maybe not for a couple of years. So the tolling provision comes in and says, okay, what if, you know, nobody figures that out right away, and it says you can bring one of these cases and it's timely if it's brought within 3 years of the material facts being known to the U.S. official charged with responsibility to act in the circumstances. So you look at that, and there's two questions presented in the case. The first one is, does that tolling language apply to qui tam cases where the government does not intervene and is not itself the plaintiff? So these unintervened relator actions. Anyone who practices in the space will know, and the you know, briefs are great about it, it's 3/4 of them are probably in that bucket where the government does not intervene, it's not bringing the case itself. So if it's, you know, this is consequential in the sense that the first question is, does this tolling language apply to 3/4 of the qui tam cases that we see out in the federal courts? And, you know, it's an interesting, you know, parry in the briefs. You know, the petition says it doesn't apply to those cases. It's meant to apply only where the government itself is at the helm in the lawsuit. And, you know, the Solicitor General on the other side says, well, actually, that's not correct. It should be the relator because they're standing in the shoes of the government for purposes of this exercise. Neither of the briefs, as I recall, really joins the issue of what the in the circumstances language means in the relevant provision. For those of you who like to look at statutory interpretation, the briefs are an interesting exercise in sort of what to do with the Supreme Court's Graham precedent 10 years ago on some of this, to say we're not going to read it literally necessarily. When you look at the briefs, you know, the petition makes the argument that based on the Supreme Court's, you know, interpretation of this before, maybe we can answer this question that way. I think the Solicitor General's brief has some pretty good arguments that this may indeed be a situation where it does apply to these relator cases. The second question then becomes really important, which is if it does apply to unintervened relator cases, what's the trigger for the clock? Because it says the tolling period runs from the time material facts are known to the U.S. official charged with acting under the circumstances. Is that the relator who's standing in the government's shoes? Or is it the government official, like at the Justice Department, who, you know, would be making decisions and can make decisions throughout the life of the case to intervene or to block a settlement or the like? So that's a pretty important question. I think, one could go either way, and I won't get into the details of the briefs on that issue. There's some legislative history that used to say, hey, it was somebody at the Justice Department. It doesn't say that now. A relator would be, congruous in the sense that if that's the entity bringing the suit, maybe that makes sense. The real practical problem arises, and I'll end with this, as Glenn pointed out in the WLF briefs and the Chamber points out, the posture of an FCA case is very, very different if the relator is the one bringing the case without the government versus the government bringing it, in the simple sense that when the government is ready to go on the litigation, it's completed its investigation. When a relator brings a case, that's the trigger for the government to start looking. And the briefs are extraordinarily good at pointing out how many years it takes. It's a 60-day aspirational deadline in the statute. The reality on the ground is once a relator files a lawsuit under seal and notifies DOJ that there may be something going on, it's often years before the government even makes a decision on what they want to do. And so the practical consequence is if the relator's the one who can take advantage of this tolling provision and file the case in the first instance, triggering the government's investigation, you could be looking at 15 years from the time of the alleged fraud. And there's a due process issue, sort of a constitutional avoidance issue that lurks here. We all litigate every day. You put out a hold notice, you look to where your custodians are. These cases, and this one in particular, this was a defense contractor in Iraq. They're there for a year. The person who was the whistleblower ended up doing some time for a kickback scheme and was in jail and here and there. These cases are not clean to litigate. They're hard to defend. So there are notice and process issues around how this timing issue plays out, whatever the court decides, that I think we're all going to have to grapple with very much going forward once we have a decision in the case.
Thank you, Elizabeth. John?
So I am planning to speak about two cases that are on the merits docket and then two clusters of cases that are in the pipeline. The two merits cases I wanted to talk about are Yahoo versus Brunetti, the follow-on to Tam versus Mittal versus Tam, and Food Marketing Institute versus Argus Leader Media, which is a scintillating FOIA Exemption 4 case. First, Yahoo versus Brunetti. So, of course, remember back in 2017, the Supreme Court held in Mittal versus Tam that the Lanham Act provision prohibiting registration of a trademark that, quote, disparages or brings into contempt or disrepute any persons living or dead was facially unconstitutional. And the Supreme Court, minus Justice Scalia, divided 4-4 on that, with Justice Alito invalidating it on one grounds and Justice Kennedy saying it was invalid on another. Long story short, Justice Alito rejected the government's argument that trademark was really a form of subsidy and that you can discriminate based on viewpoint when you're subsidizing speech. The government can choose which speech it wants to subsidize. And Alito poo-pooed that. Kennedy said he didn't have to reach it. Both of them seem to think it was a viewpoint discrimination, and that, of course, is double plus on good. The focus of Alito's version was that, even construing this as a restriction on commercial speech under the old commercial speech cases, this wasn't sufficiently tailored to be upheld there. Justice Kennedy, again, he didn't even get to the subsidy argument, and he said this is viewpoint discrimination, plain and simple, and they can't justify that. So fast forward to today. This case involves a different provision of the Lanham Act, which says that a trademark will be refused registration if it consists or comprises immoral or scandalous matter. The responsive brief has some great examples of that. Trademarks that have been refused include Madonna for wine, because I guess they thought it was sacrilegious. Koran, I don't know what they wanted to use that for. Coffee Nazi, I can sort of see that. There's a Soup Nazi brand of soups. But there's a couple that are just head scratchers. Taliban Cookie Company and Wife Beater. I don't understand the commercial appeal of Wife Beater. But in any event, it's, all of these cases are kind of amusing. The respondent in this case, he has made a living out of selling items that have a nonsense word that is a homophone for a vulgar word, F-U-C-T, and this is how he supports himself. But he went to register it, and they declined, and he sued. And the Federal Circuit found the provision was facially unconstitutional. They said, there's a decent case that this is viewpoint discrimination, but let's just stick with content. Even as a content discrimination, this isn't justified, and they struck it down. Brunetti, interestingly, the respondent acquiesced in the grant because I don't know if they wanted the argument or if they thought this is an important case, let's get it up to the Supreme Court. But he argued, and this is, he picks up on the fact that the Federal Circuit said, there's a decent argument this is viewpoint discrimination, and he makes not a terribly clear argument for why this is viewpoint discrimination, and I think it is, in fact, a colorable argument. But this is interesting for a couple of reasons. I mean, obviously, this is the first chance we have. I mean, we should have a majority opinion now in this case because we now have a full bench. And this is going to be the first case where we have it is among the first free speech cases we have since Justice Kennedy has been replaced. And, he casts such a long shadow in this area, and it has for the last 25 years. So it'll be interesting to see which way it comes out. And secondly, law nerds take note that this also presents an issue about the Marx rule for how you interpret Supreme Court plurality opinions. I mean, what is the holding of a case where there's only a plurality opinion? The court granted on that issue last term or maybe a term before that and didn't wind up reaching it, so this is another opportunity to potentially address that. By the way, hopefully no one will look back and see what my predictions were, but I think this one definitely leans respondent. I'm expecting an affirmance in this. Food Marketing Institute versus Argus Leader Media. Those who do business with the government have to turn over all sorts of information, which is very important for them to do so that the bureaucrats can ignore it. But the people who don't ignore it are their competitors. They think this is a great opportunity to find out how their competitors are doing business. But because of that, Congress put in Exemption 4, which I think is the most important exemption to the business community, which protects from disclosure, quote, trade secrets and confidential or financial information obtained from a person and privileged or confidential, unquote. Now, back in the old days, in 1974, a panel of the D.C. Circuit in 1974 consisting of Edward Tam, David Bazelon, and Skelly Wright construed that to mean it covered, let me see here, if it can be shown that public disclosure is likely to cause substantial harm to the person's competitive position, it's confidential. And literally the opinion cites the legislative history in the first paragraph, and it kind of goes downhill from that. But in any event, it's definitely a type of it's like watching 16 Candles nowadays. When you read it, it's kind of shockingly out of step with our current mode of statutory interpretation. Very tellingly, the Supreme Court interpreted the word confidential in Exemption 7 in 1993, and that was much more conventional. Here are some dictionaries, and this is what they say about what the word confidential means. This case involves grocery stores that participate in the SNAP program, food stamp program, and they have to turn over to the government their redemption data. The government, Argus Leader Media, FOIA'd this information, and the USDA said, store level information, we're not going to turn over, that's covered by Exemption 4. They went to, essentially a trial, there was a 2-day hearing on this, and USDA put on its case saying that no, margins are incredibly thin in the grocery industry, and highly competitive, and turning this information over tells people where the good stores are, the good store locations are, and they're going to put their mega center in on top of the stores that are successful. The district court found that harm was too speculative and entered judgment for Argus. The USDA signaled that they weren't going to appeal, and so a food industry organization intervened, took it up to the 8th Circuit, which affirmed. Fast forward to last August, actually I'll fast forward to 2015. That's when Justice Thomas, joined by Justice Scalia, dissented from denial of certiorari in a case to say it was a New Hampshire right to life case. where they criticized courts of appeals for not interpreting the word confidential according to its ordinary meaning, which I think they wrote means held in confidence and not publicly disseminated. So that's a good thing to have in your back pocket when you're petitioning for cert. FMI, Food Marketing Institute, filed for a stay, and they got it in August, which of course gets everybody's attention because you have to show a likelihood of a grant and a likelihood of success on the merits. At that point, everybody sits up, and of course the case got granted. Bob Loeb, who was with the Civil Division for 1,000 years, has picked up this case for the respondents, and he gave a preview in his brief in opposition, gave a preview of what the argument against the plain language argument is going to be, which is that he characterized this test, which is the National Parks Test from D.C. Circuit 1974, widely adopted throughout the country. He says that's an objective approach because essentially, and there's some good policy arguments that you don't want participants in the industry to be able to basically say, oh no, this is confidential because I treat this as confidential. You gotta respect my own treatment of it. And he argues, he cites the same kind of House reports and so forth that the D.C. Circuit picked up on. Let me see here. Oh, and he talked about how this information really isn't all that private. But anyway, it's a preview of what we'll be seeing. But I think between the fact that it is such a plain language court nowadays and the preview of the fact that the stay was granted, I can't remember the last time the court gave a stay out and that side wound up losing on the merits. I think that case also leans in favor of the petitioner. I guess that last one leaned respondent in my view. I'm going to spend the rest of my time talking about two clusters of cases that are coming down the pike. The first one is County of Maui, Hawaii versus Hawaii Wildlife Fund, and Kinder Morgan Energy Partners versus Upstate Forever. The Clean Water Act prohibits discharge of pollutants from point sources to navigable waters. And these cases present the question, what if it doesn't discharge directly to navigable waters, but into groundwater or soil where it makes its way to navigable waters? In Maui, they take treated sewage, or they clean the water up and they pump it into the ground and it leaches out into the ocean. And in Kinder Morgan, a gas pipeline burst and the gas went into the soil, and over time it's working its way to water. This is the case that raised some eyebrows when the court called for the views of the Solicitor General and imposed a deadline, which virtually never happens. I can't remember the last time it happened. And also give them a very short deadline, just a month. And it looked an awful lot like they wanted to be able to argue the case this term, the Supreme Court did. The SG agrees that there's a split and says the court should take the case. They think that Maui is a better case because they say Kinder Morgan, there's a question about whether there's really jurisdiction when it goes into soil as opposed to groundwater, Clean Water Act, get it? But I think that's a bonus issue. If you take that case, you can settle two issues instead of just one. But they've noted that in February of 2018, a year ago, they went out, APA put out a notice, asking for views of people on whether or not this is something that should be covered by the Clean Water Act. And they say, in just a few weeks, we're going to be issuing, a rule, or they weren't that specific. They say we're going to be giving guidance. And so you're going to want to wait for that to come out so the parties have the benefit of that when they're briefing the case. So I suspect that they probably, the court usually follows CVSG precedents, CVSG recommendations. So I suspect that this case will be granted. It's an open question. I think that more likely they'll keep relisting it until the rule is released and then grant it. They could also just grant it now and then hold the case in abeyance until the rules come out, whatever. The Supreme Court, they can do what they want. But I think whatever happens, it's potentially big because, Clean Water Act is such a big deal, and Justice Kennedy was the kind of dividing line. He didn't join Scalia's opinion in Rapanos, causing, much head scratching about what exactly the rule was going to be. And so anything they could say, to sort of shed light on it, that people can read the tea leaves of where the Clean Water Act is going to go for standards of the navigable or waters of the United States. Although I think that's they should be able to steer clear of that in this issue. But also just because every utterance is so significant. You know, in one of the last CWA cases he did, you know, Justice Kennedy mused about whether or not the Clean Water Act was unconstitutionally vague. And then, you know, the one big one before that, Justice Alito, you know, kind of mused that just a jurisdictional determination that, you know, something is covered by the Clean Water Act, whether that is final agency action, which wound up eventually becoming the law. So everybody's going to be watching it very closely. You will have to arrive early to get seats in the courtroom for that one. The last cluster is cases everyone here will have heard of: Bostock versus Clayton County, Georgia; Altitude Express versus Zarda; and RG and GR Harris Funeral Homes versus EEOC. These are the ones about whether Title VII of the Civil Rights Act of 1964 covers sexual orientation. That's the first two. And then gender identity / transgender status, which is the third. Price Waterhouse versus Hopkins, it's a plurality opinion, indicated that failure to act in accordance with or penalizing people because they fail to act in accordance with sex stereotypes violates Title VII. And the Seventh Circuit and Second Circuit unbanked cases in order to overrule prior precedent and to hold that Title VII does cover sexual orientation. And the Second Circuit never unbanks. They unbank literally 7 cases out of 1,000. So it's you know, people sit up and take notice when they do that. It's not like the Seventh Circuit goes crazy with it, but you know, have 2 unbanks in there is an awful lot to pay attention to. The EEOC took the position of the Obama administration that I think gender identity was covered. The respondent and Bostock, however you pronounce it, recognizes, acknowledges the circuit split. They still argue against it. The EEOC, in their brief, say there's a split and these are recurring and important. They say you should. They actually don't say you should take these cases, but I mean they say they meet all the criteria. But they do say you probably should hold the transgender one because it doesn't rise as frequently as the sexual orientation one. But I think the case was already a decent candidate. It's been relisted 3 times, which under the work that we have done in trying to put people to sleep shows that after 2 relists on the most recent statistics, it stops being like, oh, this is really grant bait, and like, maybe this is looking more like a dissent from denial or a summary opinion or something. But in the last couple of weeks, Judge James Howe wrote a separate opinion. This is one of these things, it's like these were unheard of until a couple of years ago, and now you see them everywhere where people concur in their own opinions. A 14-page concurrence to a 6-page majority opinion where he talked about, I think the thing that matters the most here is he said that, he basically says that there's a split. And he makes his case for why the cases that take the other side of the view, that is that this isn't covered by Title VII, are right. He says, the original public meaning, there was no question, nobody thought this was covered. And he makes other types of arguments that he's trying to, I think, persuade the Neil Gorsuches of the world. But I think this is interesting. It looks an awful lot to me like he's just trying to weigh in on the split and put his thumb on the scale of this. He's a very speedy judge. His average is 45 days from argument to opinion in cases without a dissent, and 55 when there is a dissent. But he got this one in a brisk 29 days, which looks to me like he was trying to beat the February 15th conference. But we will see. I do think, though, that it's interesting, because there are a lot of people who assume that conservatives will think that the employees will lose on this, but I don't think that that's necessarily a foregone conclusion. When you look at the Second Circuit en banc, Judge Dennis Jacobs concurred in the opinion to say basically that if you can say women ought to have they ought to be demure. Isn't that far off from saying, women ought to, marry men? And Judge Cabranes, who, he's a Democrat, but he's a fairly conservative one, and they're both fairly, decent proxies for what some of the, center conservatives on the court might do, like the John Robertses of the world. So I think this one will be a very interesting one to watch, and I do expect that it'll be a grant.
Thank you, John. Michael?
Hi, everyone. So I'm going to focus principally on some of the administrative law cases that are pending before the court right now. After talking about a handful of those cases, I'll say a little bit about some of the arbitration cases. And then, time permitting, although I think it'll be a fairly short remark, I'll share some thoughts about some developments that I think are worth keeping an eye on. So for what is, I think, a relatively quiet term, this is a pretty big term, I think, for administrative law. I think, largest and highest profile of these cases is one that I'm involved in with my colleagues at Mayor Brown, Kaiser against Wilkie, which presents the question whether Seminole Rock and our deference should be overruled. The case comes before the court out of Veterans Affairs proceedings that were then appealed to the Federal Circuit. The question in the case, this is a request for benefits under federal law, which not unlike the Social Security Act has an administrative claims process. There was a request to reconsider a prior denial of benefits on the basis that the VA the first time around had failed to consider relevant records in the claimant's file. If those records are deemed to be relevant, then it's a basis for reconsidering the original claim, and that matters because if it's on reconsideration, then and there is then a grant of benefits. The grant of benefits will be retroactive to the original request. If the records are not deemed relevant, then the request for relief is treated as a motion to reopen. And in that circumstance, you cannot get retroactive benefits. And the benefits sought here date back to the 1980s, so this would be a substantial amount of money for our client in the case. So the administration denied benefits, and it denied them on the basis that the particular records at issue in the case were not relevant. And in doing that, the administrative law judge suggested that for a record to be relevant, it's not enough that it relate to or bear on the issues in the case. It also must be singularly dispositive. So if it wouldn't singularly change the outcome of the original request, then in the agency's view, the record is not relevant. That doesn't quite jive with the traditional understanding of what a relevant record is, which is anything that would bear on or relate to the underlying claim. So this was an issue that our client challenged through the Federal Circuit, and the Federal Circuit said, well, the word relevant here is ambiguous. We could see it both ways. There's some merit to the government's position. There's some merit to the claimant's position. We're not even going to consider resolving it. We'll just rely on our deference, and on that basis, they denied benefits to the claimant. In a series of, I guess it was probably the third in the last few terms, of cert petitions presenting the question whether ours should be overruled, it seemed unlikely that the court would take the case. We figured it was a good enough shot, certainly, to warrant the petition, and in the end, the court took the case, as everybody knows, limiting it, however, to the first question presented, because there was a second question in the case, and I'll come back to this in just a moment. The second question in the case was if there is another substantive canon of construction at issue, whether deference trumps that other substantive canon. So this comes up frequently in the criminal context when questions of deference are pitted against the rule of lenity, which requires construing criminal statutes to favor criminal defendants. In this case, there is a rule of construction favoring claimants in the Veteran Affairs Administration. So the second question presented in the petition was, assuming the court retains our whether the agency itself has to apply substantive rules of construction that apply to courts and private litigants before courts, or instead if deference can be sequenced before these other substantive canons. As I say, I'll come back to that in a minute. So the court granted only on the first question, whether Howe should be overruled, and I think that's a pretty clear indication of where the court is going to go with this case. We raise 4 general categories of arguments, I think all of which are independently pretty powerful. The first is that our deference is a circumvention of APA notice and comment rulemaking. When agencies set out to establish rules that bind parties, they have to give the public notice of their proposals, take comment, respond to those comments, and then subject their ultimate decisions to judicial review. Our deference encourages agencies instead to skirt the difficult issues by promulgating vague regulations and then filling those vague regulations with actual substantive content through informal interpretation of their own regulations. And then ironically, our deference gives deference in circumstances even where, by analogy to a regulation, Chevron would not. So a agency's interpretation of its own regulation needn't be formal. It can be informal guidance. Indeed, it can even come in the form of an amicus brief filed before a court. And in those circumstances, under our as it stands today, courts would have to defer. We think that's an end run around notice and comment rulemaking. We've also, in this case, and I think you've seen it also in a lot of the amicus briefs filed in the case, there's been a concern to build a firewall around Chevron deference. I think the sense here is that the more liberal justices on the court are more likely to buy an argument against our if they don't believe that voting to overrule our will lead immediately to overruling Chevron. And so among the amicus briefs and also in our party brief, arguments have been made that the underpinnings, the theoretical underpinnings of our really are not consistent with the theoretical underpinnings of Chevron, which is that Congress implicitly delegates rulemaking authority when it leaves an ambiguity in a statute. That same rationale just doesn't translate when you're talking about vaguenesses present in regulations. And of course, there are the separation of powers concerns as well, because if agencies have the final say in the interpretation of their own rules, then the lawmaker becomes the law interpreter as well, and can, under the circumstances in which it's being asked to interpret the law, make the ultimate regulation mean whatever serves its interests in that particular case, and that implicates a lot of the traditional separation of powers concerns. So I think some things to look out for at the argument, which is going to be March 27th, is how vigorously the more liberal justices on the court, and I'm thinking in particular in this circumstance of Justice Kagan and Justice Breyer, how vigorously they defend our. I think that will be an indication of their concerns that voting to overturn our might be an invitation to overturning Chevron, about which I think there's a lot more concern. And so it'll be interesting to watch. I think in the end it's likely that we'll see our either extremely narrowed to the point of irrelevance or being outright overturned, and the question is what sort of a path is left behind to eventually attack Chevron deference. Now, I did mention that there was this second question in the case, and I'm going to briefly touch on that question as it comes up in another case that I think might be a little bit of a sleeper case. It's Smith against Berryhill. It's a Social Security case. The question is when, under what particular circumstances courts have judicial review over decisions of the Social Security Administration. The rule up until this time has been that if you don't fully exhaust administrative remedies, it isn't that is an affirmative defense in follow-on litigation. It's that it is in fact a bar to federal court jurisdiction altogether. This is another case that I and my colleagues are handling. It's a case that I'll argue on March 18th. The Solicitor General, interestingly, confessed error in the case, and so the court has appointed an amicus. I think the merits of the Social Security Act question itself aren't especially pertinent, but the case does present, in the end, the second question that's presented in Kaiser, only it presents it in the context of Chevron and not our deference. In this case, the Social Security Administration has had a regulation on the books since the 1980s, and that regulation runs headlong into the substantive canon favoring judicial review, and the question is which will win out. Does the agency have to consider the canon favoring judicial review, or is it free to ignore substantive canons of construction, issue its own policy-based determination, and then courts must defer? So there's a chance that the court will end up disposing of that case in a way that doesn't present that question, but I think there's a reasonably good chance the court will be confronted with that question inevitably in Smith against Berryhill. I'll say something now just quickly about PDR networks, which is another, I think, very interesting and important administrative law case that dovetails with some of the Clean Water Act issues that John was raising earlier. The question in PDR networks is a question that arises under the Hobbs Act. The Telephone Consumer Protection Act prohibits entities from sending unsolicited advertisements over facsimile. I didn't know anyone still used facsimile, but apparently they do. In 2006, the FCC promulgated regulation saying that this prohibition covered not just solicitation for business, but offers of free products. That regulation, in turn, is subject to the review provisions of the Hobbs Act, which provides that broadly applicable rules like this must be challenged within 60 days by a petition for review to the courts of appeals. And in turn limits that provision to only those who participated in the rulemaking process. So if you didn't participate in the rulemaking process, you're denied statutory standing. So the question in the case is if a party did not file a challenge to the underlying rule within that 60-day period, but is then later subject to an enforcement action in which the legal validity of the regulation is put at issue, is that private entity against whom the regulation is being enforced effectively estopped or prevented jurisdictionally by the statute from raising a facial challenge to the validity of the underlying regulation itself, as opposed to just concerns about its particular application in his case. This is a structure of review that arises in a lot of other contexts, including the Clean Water Act, the Clean Air Act, and a number of others, that provide citizen enforcement actions and other, of course, regulatory enforcement actions, while also providing for particular procedures for obtaining review in the courts of appeals of large rulemakings. This question is bubbled up in those contexts as well. It's presented in terms of res judicata or denial of jurisdiction in the district court. In this case, the Fourth Circuit said that the district court, in fact, lacked jurisdiction to consider the validity of the underlying regulation, and it, in fact, had to take the regulation as valid because it did not arise under the Hobbs Act procedure. The arguments made in the case, there is some overlap, I think, also with Smith against Berryhill. Of course, there's the presumption of reviewability is raised in the case, as are very specific arguments pertaining to the Hobbs Act text itself. But more broadly, if the court reaches them, there are also more systemic arguments that the parties make, and I think make quite persuasively, about due process concerns for regulated parties who might not even have been incorporated at the time that the regulation at issue was promulgated, and yet their hands are tied by the fact that they didn't participate in the challenge to the rulemaking at the time. And there are similar separation of powers concerns that arise in the Kaiser and Smith cases as well. So I'll say something very briefly about the arbitration cases, which admittedly are not so much my wheelhouse. New Prime is a case that was decided in January. I know it's a decided case and so isn't in the pipeline any longer, but I think it's one worth watching. because it has significant potential consequences for rideshare programs. The FAA, the Federal Arbitration Act, has a carve-out for, quote, contracts for employment in interstate commerce. And in an opinion by Justice Gorsuch, the court said that the question of the FAA's scope is one for the courts, and that contract for employment does not require a formal employee-employer relationship. And this derives from the fact that the statute uses the term worker and not employee, and that at the time that it was enacted, contract for employment was understood to, employment was a broader term than just the very narrow employer-employee context in which we might think of it today. The reason I think this is one to watch as courts below deal with the holding is that it has significant implications for Uber and Lyft and other ride-sharing programs whose drivers are independent contractors. And I think the question that will come up in later cases as rideshare programs may attempt to arbitrate cases is whether these drivers are drivers in interstate commerce, because if they are, now under new prime, they're exempted from that Federal Arbitration Act, which is a pretty big deal. I'll stop there on the arbitration stuff and pass it back to Glenn. Thank you very much.
Thank you all. I wanted to give our speakers an opportunity to weigh in on any of the cases that the speakers after them had a chance to talk about. For instance, Elizabeth, if you have anything to talk about, to mention with any cases that two of them spoke about.
It was funny. I was just making a note when Michael was talking about, obviously we focus on text, but the point in new prime about worker versus employee, one thing I forgot to mention that struck me, and this is again a bit nerdy, but it'd be interesting to see in the Cochise case, which is the False Claims Act case, there's the question of what is that language about, the official charge to act under the circumstances in the false claims case? What does that mean? I touched on what does under the circumstances mean. It could be where the government doesn't intervene. But the other thing I thought very interesting about the Solicitor General's brief on this, sort of semantic point is it says official, not officer. But when you read the SG's brief, a lot of their argument about why it should only apply to the United States as a party draws on appointments clause jurisprudence about who is an officer of the United States for purposes of appointments. So I think that'll be interesting to see how the court, particularly this court, looks at that issue on the text, which seems maybe deliberate.
John, any thoughts further on Michael's?
The one thing was I thought it was very significant that the court took the case they did for this hour deference thing. I mean, they took a very sympathetic case involving like a veteran or whatever, and to me, that seems very strategic. There have been a ton of cases, well, I guess ton is a bit of an overstatement, but there have certainly been petitions in the past that presented this issue that have come up, and I would not at all be surprised if the enemies of our have been biding their time looking for a particularly good vehicle, so they hope they can get a tailwind. And that's one way of interpreting it. If the case comes out totally inconsistent with that, forget I said it.
While you have the floor, John, I wanted to see if you could mention a little bit about the Parker drilling case that I mentioned at the outset. WLA filed a brief in support of CERT, as you did for some of the oil company clients as well.
Sure. This is a case involving the Outer Continental Shelf Lands Act, which is just a statute governing essentially oil rigs and things that happen, basically on the Outer Continental Shelf. The law is not terribly clear on this about how basically federal law jibes with state law on these things in the oil rigs. The Fifth Circuit has adopted one rule that is much more leans towards federal law, and the Ninth Circuit fairly recently held that all of California state labor law more or less applies on the oil rigs, including like minimum wages and overtime rules, which is a big deal because people are on call the whole time they're on rigs, because they might be even when they're lying in their bunk, they might be required to put out a fire or something on very short notice, and so that might count, that does count as working hours under California law, and so suddenly you have a lot of overtime. Whereas it's its own different world in that, most of the oil rigs, you're 2 weeks on and 2 weeks off. And so you work intensely for 2 weeks, but then you don't do any work at all. And yet you get paid for all of that, and you're paid actually fairly handsomely. But what this might mean is a bunch of retroactive liability. My recollection is that on rehearing, they tried to suggest that, that it might apply this going forward only or something, in an effort to try to take the wind out of the sails of, Supreme Court review for this thing. Paul Clement managed to get cert granted on this. I don't have an inferiority complex at all that I had a Outer Continental Shelf Lands Act case denied two or three terms ago. But it'll be very interesting to see what happens with that one because, I think the conventional wisdom is they didn't take this case to affirm. Sometimes the court takes a case to reverse and then changes their mind. But it'll be very interesting to see what happens here. But, one of the arguments we made is that even though it's essentially only a 1 versus 1 split, those are really the only jurisdictions that have offshore drilling are the Fifth Circuit and the Ninth Circuit. And apparently the court agreed.
So if you're online, you can ask questions directly to me, and I will provide the questions to the speakers. Is there anybody in our audience that would like to ask a question? Yes.
I have a Kaiser question for Michael, and it relates to the separation of powers. So if I could compare language to space, Congress delegates to the agency and gives them, 1 foot of space, and that's the chevron space. And the agency, we know the agency can't make a foot-long regulation and get deference, but they go in and they make an 8-inch regulation, and that's their hour space. And then they interpret it somewhere in that 8 inches, and we say, hey, that's a separation of powers problem. You're in effect making the law there. Well, if it's a problem in 8 inches, why is it not a problem in the 1 foot at the earlier step? So if it comes to oral argument and someone like Justice Gorsuch walks us through this and says, look, you've delegated legislative power, it's a separation of problems, and someone like Justice Breyer speaks up and says, well, hey, that's an attack on Chevron too. The only answer I can come up with that's purely about separation of powers is, well, it's one thing to say something in an amicus brief, at least the agency's doing notice and comment, which is all well and good, except that's not what the Constitution says. You can't skip the legislature, not put it through the houses, not have the president veto or sign, and then say, well, that's law under Article 1. So is there an answer there for the Justice Breyer type that specifically relates to separation of powers to say, no, this is different. You can attack our on this ground, but not Chevron?
Well, so I think the best answer to that question doesn't arise on the basis of the separation of powers argument. I do think the best answer is the circumvention of the APA, which ultimately is, I think, ought to bring comfort to any of the justices who are inclined to want to uphold Chevron. The way that I think about it is if you've got that 10-inch space and the public, under the way that Chevron and the APA is supposed to work, the public should get notice about which point along that 10-inch spectrum the agency is going to put its regulation. If it's at inch 2, I get to comment on what's wrong with inch 2. If it's at inch 6, I should be able to comment on what's wrong with inch 6, and the agency ought to defend and justify its decision to put it at inch 6 and not inch 2. The problem with our, of course, is, as you say, it just produces another window. And if that window covers inch 2 and inch 6, then the decision to pick one over the other is exempted, in effect, from notice and comment because it's achieved later by interpretation rather than by notice and comment rulemaking. I think concluding that that's what's wrong with the scenario that you described is entirely consistent with Chevron deference. Chevron, I think, respects the notion that Congress can delegate certain effectively legislative functions to expert agencies that are in the best position to make policy judgments about what's most appropriate under the circumstances. And nothing in at least the nature of the arguments that we're emphasizing, and I'll say nothing in the arguments that we're emphasizing calls that into question. I should say separation of powers, I think it's more of a sort of structural and theoretical explanation with what's wrong with it. Chevron certainly doesn't implicate the same problems because, of course, courts, as long as courts have the authority to interpret regulations, then it won't be the rulemaker and rule interpreter residing in a single branch. But that's, in the end, I think the separation of powers stuff, although I think it's what a lot of people like to talk about, ends up being mostly atmospheric. I think really what it comes down to is the APA and the proper operation of Chevron deference and how ours is consistent with it.
Thank you.
Any other questions from our audience? Rich?
You've certainly done a good job of trying to explain to the worried justices that Kaiser won't in any way threaten Chevron deference. I understand, though, there is a pending cert petition that Quinn Emanuel has filed on behalf of UPS that raises a credible argument challenging Chevron deference, and I'm wondering if, particularly if it's likely that comes up for conference before there's a decision in Kaiser, do you think that there is any stomach in the court for taking on that issue for next term?
I guess I'd be interested in hearing what the other panelists have to say about that. I think what we've seen so far this term since Justice Kavanaugh's appointment is a pretty cautious court. I don't think certainly the Chief Justice isn't especially eager to feed the notion that the appointment of Justice Kavanaugh is now the license to aggressively pursue what's considered a conservative agenda, whether it's in more lawyerly contexts like agency deference or the other social contexts. I think it would be a surprise to me if we saw a grant on the validity of Chevron deference anytime in the next, for at least a couple terms after they decide this case.
I think it'll be kind of interesting to see just what they do with that case during the pendency of the hour challenge, because ordinarily the court has an extremely broad view of holds, what it holds. It will hold a case if it might be affected by, the outcome might be affected by what the court is going to do. And it'd be interesting to me if they conspicuously deny cert in that case and don't hold it in order to calm people down. But that'll be an interesting thing, I think, to watch.
Yeah, I was going to say watch the hold versus the denial, and I think to the broader point, this picks up on one last case that Glenn mentioned, that I think the foundation filed the brief. On the issue, John's point about tailwind, I think it's right, and I agree with Michael. This is a cautious court. They're not looking to make a sea change. But if you look carefully, you can see the sort of ladder developing, right, in some of these areas. And we talked about some today, like in the Emulex case on implied private rights. You can see this in the briefing. There are members of this current court who are going to take a much harder look, I think, than in the past, even post-Sandoval, on implying rights in federal statutes. The Apple case, we're seeing the same thing like in the antitrust contracts. It's not that the court is looking to upend traditional doctrines abruptly, but like last year in American Express, traditional antitrust doctrine had said, you define an antitrust market by people buying similar things, right? What a cardholder gets from a payment card network is not the same as what a merchant gets, but they kind of, in the Apple case where the foundation filed the brief, you saw the argument, it was around Thanksgiving. Very interesting argument about Illinois Brick and the fact that Brick had two components. One was where is the monopoly located in the supply chain, and the other issue was the pass-through pricing. And there was a lot of pushback and exploration from the court. So I think on these kinds of, whether it's APA deference, whether it's traditional antitrust doctrine, whether it's implied rights of action, I think all of us who are briefing these things and looking for vehicles going forward, to kind of read the lattice a little bit, because I don't think it's going to be abrupt, but I do think it's there.
Any further questions from our audience? We'll bring our proceedings to a close then. I want to thank all of our speakers today for joining us. Certainly will be an interesting second half of the court. And for those of you who joined us online, either early or late, if you didn't get a chance to see everything, this will be available on our website later on this afternoon. If you have any colleagues or friends who might want to watch it, please feel free to let them know that as well. Thank you again.